Welcome to our video series on types of trusts and how they work. Today we're going to be addressing a married couple's estate and what takes place when they pass, whether they have a will in place or a living trust, and show the potential gain or loss to the estate. We're also going to be looking at the different types of married revocable living trusts available to gain a better understanding of their general differences. But first, let's take a step back and briefly address what happens if a person has done no estate planning at all. They don't even have a simple will. Well, if they don't have a written will in place, their estate has one for them. This is called dying intestate, which simply means you have no documents in place that discuss the distribution of your assets. That being said, their estate has a will for them, although far more complex and not written to their desires. The courts will determine who owns the assets, and this process can cost the estate dearly. Now, if they do have a will in place, it's better than nothing. Unfortunately, all wills are destined for probate. Probate is the dreadful court process that determines title to assets. For example, both parents pass away and you and your siblings are ready to sell their home. If the home is titled in their name, the courts will now determine title, or who should own that property, and it could open the door for contention among the family, even if the will stipulates who should receive the assets from the sale. Probate invites contest. It is also time-consuming and public and can cost the gross estate in upwards of 8% with legal and administrative fees. So some may say, however, probate's not an issue. I can avoid that process by using joint tenancy. And that is true, but only when the first spouse passes away. Any assets titled in joint tenancy will be subject to the probate process upon the passing of the surviving spouse. If those assets need to be sold or transferred into their children's name, the courts will be the ones to do it. Again, this can be costly to the estate, and it's definitely not a timely process. There are other drawbacks to using joint tenancy as a planning method, and to learn more about joint tenancy, you can view our pitfalls of using joint tenancy video. So what's the best solution for a married couple? The best solution could be a revocable living trust, which gives the couple a number of benefits, the greatest of which is control. If that trust is fully funded, there would be no probate and no cost of probate to the estate. Let's take a look at a comparison of a $500,000 estate with a will versus a living trust. We will assume a $1 million federal estate tax exclusion for 2013. With a will and a trust, a $500,000 estate would not be subject to federal estate taxes. However, the will would be subject to probate. If assets need to be sold upon the death of the first spouse, this estate would pay $40,000 to the probate lawyers in courts to determine title to the assets. This would be assuming an average cost of 8%. Then, after the death of the second spouse, the estate would be subject to the probate process again and pay another $36,800. In contrast, the trust avoids probate and the heirs do not lose $76,800 of their inheritance. The living trust itself affords the individual the right to say who will manage their estate once they pass, who will receive their assets, and how those assets will be distributed. The trust protects the individual's privacy and preserves their estate. They also have the right to change the document at any time while living. And most importantly, they pass assets to their family quickly and efficiently without courts. A married couple can plan by using a Married A, Married AB, or Married ABC trust. And the simplest way to understand the differences between the three types of trusts is based on the size of the estate. There are many other determining factors between them, but this is a very basic explanation. If the size of the estate is close to or will ever be more than the federal estate tax exclusion, you would want to look at the Married AB or ABC trust. If the estate's well under the federal estate tax exclusion, you could consider the Married A trust, but like I mentioned, this is a very basic difference between them, and other factors would need to be considered. Let's take a look at those factors and how the benefits of subtrusts come into play. What do I mean about subtrusts? It's the A, B, and/or C portion of the revocable living trust. These subtrusts come into effect after the passing of the first spouse. When that spouse passes, the assets get divided between the trusts. The easiest way to remember whose subtrust is whose is A is above ground and B or C is below ground. Now, these are not separate trusts, they are subtrusts within the revocable living trust. Let's look at an example. A $500,000 estate would be divided as follows. Again, we will assume a $1 million federal estate tax exclusion for 2013. The $500,000 of marital assets would be divided in half going in A and half going in B. You may also come to know the B trust as a bypass or credit shelter trust. The $250,000 in the decedent's B portion is now irrevocable. That means their share of the assets and how they want those assets to be distributed can no longer be changed. This provides protection for the heirs of the decedent and is just one of the many benefits and functions of the B subtrust. Other benefits include protection from creditors, and the growth of the assets are sheltered from future estate taxes. The B trust is especially important for those couples in a second marriage. If the couple has children from their previous marriage, the assets are protected from unintentional disinheriting. For example, if the husband passes away, the surviving spouse cannot change his beneficiaries and make her children the recipient of his portion of the estate. It ensures his children will be taken care of after his death. Now we've looked at the benefits of the B subtrust. Now let's take a look at the C subtrust. The C trust is essentially an overflow bucket or a holding tank for extra assets, which means that it holds anything over the federal state tax exclusion amount. So here's an example. A $2.5 million estate would be divided as follows. We will assume a $1 million federal state tax exclusion and 55% federal estate tax for 2013. Again, the marital assets would be divided in half, half in A and the B subtrust. However, since the amount in the B trust would be over the $1 million federal state tax exclusion, we will only fill the B trust up to that exclusion amount and place the overage of the $250,000 into the C subtrust. Why would we do that? The C trust allows for estate taxes that would normally be due at the time of the first spouse's death to be deferred. The C trust is also essential for blended families as, again, it keeps the decedent's heirs from being unintentionally disinherited. Upon the death of their surviving spouse, the estate would be subject to paying 55% on the amount over the federal estate tax exclusion. In this example, it would be the $250,000 from the A trust and the $250,000 from the C trust. And the estate would pay $275,000 in federal state taxes. So you may ask, what's the planning benefit of using the C trust if I still owe all those taxes? And the answer is that the surviving spouse can use the money in the C trust and hopefully spend it down so that the tax amount is less at the time of her death. The C trust is also known as the Q-tip part of the trust. You may have heard this term thrown around, but essentially the C trust includes Q-tip provisions. Q-tip stands for Qualified Terminal Interest Property. So for the trust to qualify for tax deferral, the spouse must have a lifetime right to the income of the property. The surviving spouse must be entitled to the income generated from the assets in the C trust in order to maintain her standard of living. The C trust also holds Q-dot provisions. And Q-dot stands for Qualified Domestic Trust, which is essential for a non-citizen spouse. The non-citizen spouse must have a co-trustee that is a citizen. Now, without confusing the issue, a married person can also decide to use a single A trust or single A Q-tip trust instead of a married trust. This could be appropriate planning for any couple that holds their assets separately and they want to set up a trust independent from their spouse. It doesn't happen often, but you may come across a situation and there is an appropriate planning solution. It is also imperative that everyone have the necessary ancillary documents in place. This means a power of attorney for assets, power of attorney for healthcare or a healthcare directive, living will, and a nomination of conservator. Our trust package includes these essential documents. For more details on ancillary documents, check out our video, How Do I Protect Myself While Living, where we address the power these essential documents hold. In summary, trust planning addresses a number of different concerns, including some taxes, supporting a disabled child or children with money management problems. The options can be endless. Couples want to preserve as much of their estate as possible for their heirs without having it diminished by extensive legal fees. They want to retain control over their affairs. They want to pass their assets how they see fit, and they want their private business to remain private. The married trust options provide extensive flexibility to solve a number of planning issues, and this equals peace of mind, knowing they have the right documents to protect themselves and their family from unnecessary financial drain.